Let me begin by thanking Jarek and Anna for having me and for the very generous words of introduction, setting up an almost impossible benchmark to achieve. There's a lot of in the remarks about food and courses, and I think that there's even a reception to follow. So we are perhaps already set on an auspicious course. The title of my talk today is Compensation and International Dispute Settlement. And you will appreciate that puts the Venn diagram between what I am going to speak about and what you are looking at your other classes as somewhat short of a full circle. In some respects, I will speak about arbitration and other things. So arbitration generally being viewed as applicable in the context of dispute settlement bodies constituted, created for the particular dispute, and dying with its end, becoming formlis officio. That will be one part of things that I will speak about, but I will also speak about permanent judicial bodies in international law that consider issues of compensation. So, International Court of Justice and International Tribunal for Law, the Sea. And when I speak about arbitration, I will look not only at commercial arbitration and investment arbitration, so arbitrations that have a non-state actor, but also arbitrations that operate in the interstate setting. So in that sense, the net will be thrown more widely. In other respects, it will be somewhat more narrowly drawn. I will be looking only at those bodies that consider our claims of compensation based on common international law. Jarek mentioned that I'm the Special Rapporteur on compensation for the damage caused by nationally wrongful acts. It's a bit of a mouthful. But each word, as you will hear, has its meaning and relevance for being there. So only be interested in questions where allegations and breaches of international law are at play. It doesn't mean that it is always entirely clear when such is the case. Whether or not something is a breach of international law may on its own be a subject of a great deal of controversy. When you consider investment arbitration, for example, there are important questions to be debated, as the Vivendi Annulment Committee taught us about contract claims and treaty claims, and trying to get a sense of which of them is at issue. And of course, sometimes looking at these matters solely from the perspective of applicable law may miss the real importance of the policy issues at play in different arbitrations. Charles Brouwer, a couple of years ago, coined the phrase investomercial. Perhaps not the most elegant word. I don't think it has really caught up, but I think it does capture importance and start a proposition that in many respects there are commercial arbitrations with state-owned companies, commercial arbitrations regarding natural resources that raise policy issues very similar to those as in investment arbitrations. Also, significant exposure of states financially, public policy issues, and so on. So, even though I will not be looking at them to the extent that they are not taught by public international law, this is merely a descriptive point. I'm not saying that non-public international arbitrations are not important or relevant. That just an aside, the question of how to best capture the variety in international dispute settlement is something that we are discussing now in the International Law Commission under the guidance of Special Rapporteur August Reinisch, also a very prominent both writer and arbitrator in international investment arbitration, regarding the topic of settlement of disputes to which international organizations are parties. So think perhaps Heidi cholera and such disputes. And we have had a considerable degree of discussion of whether it is best to think about these disputes by reference to applicable law, international law, or otherwise, or parties, private parties, or otherwise. But that is by way of background of what I will be looking at and what I will not. Why compensation? Let me start with a nod to a great figure of international law that is unfortunately no longer with us, Judge Professor James Crawford, who departed this world about 5 years ago. So a very prominent figure in international law, and has also done many important contributions to the particular topic of compensation. When receiving the Hudson Medal, which is probably one of the most prestigious prizes in international law bestowed by the American Society of International Law, Professor Crawford recounted a story of a conversation that he had had with a student in Cambridge. And that student had told him, Professor Crawford, that he, the student, was interested in investment law, in particular that he was quite interested in understanding the substance of investment law. What is it that fair and equitable treatment and indirect expropriation mean? Conversely, the student didn't care a great deal for damages. And so the way how Judge Crawford then summarized his reaction, he said, well, in his experience, clients usually do not share that perspective. So damages and compensation, and not perhaps even somewhat boring and technical question, but one of great importance. And one can perhaps appreciate the variety of reasons why compensation and damages might shift a bit to the background in the inquiry by a lawyer. So just as a matter of chronology, they seem to come in rather late in the intellectual inquiry. So really looking at your program, parties, applicable law, evidentiary issues, merits, recognition, and enforcement. Compensation intellectually fits in somewhere about 3/4 of the way through, where the legal mind is probably already counting in that they have won or lost the case, and is rather thinking about how to set things aside or recognize and enforce them, or conversely, try to resist all of those things. Also, there is something almost non-lawyerly about issues of compensation and damages, so the extent to which one has to speak to people who understand numbers, perhaps bring in accountants, think through complicated mathematical models, get into complex abbreviations like DCF, explore concepts like sunk costs, sort of things that seemingly belong to a very different faculty than the law faculty, which we have so much enjoyed in our younger days. So, very important, overlooked and perhaps treated with a degree of caution. As a result, sometimes it may be the case that those are the non-lawyers who come in front and center in cases on compensation. But these are matters of great importance, and let me just give you a couple of recent examples. Yesterday, the Permanent Court of Arbitration released for public read the arbitral award in an interstate dispute regarding the dispute concerning coastal state rights in the Black Sea, Sea of Azov, and Kerch Strait between Ukraine and the Russian Federation, for which a claim for reparations was an important element. And the tribunal noted, by reference to an old case rendered by the Permanent Court of International Justice in the late 1920s, to which we will return at Horzov, reparation must, as far as possible, wipe out all the consequences of the illegal act. Where there is no illegal act, there are no consequences to wipe out, and thus no reparation due. A couple of weeks ago, the International Tribunal for Law of the Sea rendered an award in the case Heroic Idun, the Marshall Islands and Equatorial Guinea. Again, Chapter 12 of that case dwelt in great detail on issues of reparation. Getting closer to the core of our subject matter, several important decisions have been released in investment arbitration in the last few weeks, and I particularly note the February decision February decision by the Permanent Court of Arbitration in the famous case Chevron and Ecuador, which the tribunal slightly tweaked the arbitral award that had amounted to more than $220 million in that case. And that is not necessarily the largest arbitral awards that one has in investment arbitration. They are very high arbitral awards indeed. Tetyan Copper and Pakistan, ConocoPhillips and Venezuela, $7-8 billion. Several important arbitral awards against Latin American countries such as Ecuador, Venezuela, beyond $1 billion. The famous award against the Russian Federation brought by the Yukos claimants, $50 billion. So these are very important high stakes decisions. Also, as you would have seen from my examples, these are things that first are happening all the time. So these are really examples that I have taken from a couple of weeks and months. Examples that occur in very different substantive settings. They may be part of very broad and sensitive interstate conflicts. They may be emerging as a fairly routine element of law enforcement operations, as it was in the ITLOS case, and they may be variously either commercial or public policy in nature, but with very significant policy and financial stakes. Also, on the 27th of May, the same day that the heroic Idun Award was published, International Law Commission released for public read my first report on compensation of the damage caused by internationally wrongful acts. Now, I would like to say that you should go to the ILC website and read it, but from the beginning of last week, United Nations document system has broken down, although it has been promised that it should be coming back up online the next 2 days. So I think it will be there for a long time, so perhaps you can resist the temptation to read it immediately. But essentially what I want to do is to talk you through the first report and explain what, in my view, the key issues are in international law of compensation and what it is that the International Law Commission for the next few years could do in this regard. So there's a degree of exclusivity about this issue. The report was published in late May and will be discussed in the International Law Commission in the 2nd and 3rd weeks of July. So you may be the first audience that hears the verbalization of my thoughts on the matter. So I have about half an hour or so to guide you through things that strike me as important, interesting, and explain my thinking on the matter, of course, with an eye, and I appreciate that you have come here to think more particularly about arbitration, how that might arise in practice in these cases. Let me first say a few things about compensation and the law of state responsibility, because it is important to understand where this topic fits within the international law. And I know from Jarek that some of you are very knowledgeable in international law and others might have treated it a bit more lightly. So let me just do a bit of situating work. The main document that guides us in this regard is an earlier product of the International Law Commission, published a bit before my time in 2001, the Articles on Responsibility of States for Internationally Wrongful Acts. And those are things that should be available online if you want to bring them up before your screens. That is not a treaty. International Law Commission is a body, is a subsidiary organ of the General Assembly that is there to contribute to progressive development and codification of international law. It occasionally does provide treaty drafts that states then pick up, but for this particular document, we are interested in it to the extent that it may be reflective of general international law, in the sense that it is not binding because the International Law Commission adopted it. It is effectively binding because it tells us with great authority what the content of binding rules is. And in many respects, indeed, perhaps in most respects, courts and tribunals and states have treated ILC articles as accurately stating applicable law of the matter. ILC articles come in three parts. There's a fourth part, but that is really a miscellaneous bit that comes in three substantive parts. And this is something in a sense of a conceptual framework that will probably be a bit easier for those who are civil lawyers to get to grips with than those who are common lawyers. Because it proceeds on the assumption that rules on responsibility, so rules that tell us in what circumstances international law is breached and what the consequences are cross-cutting, so that they would apply whatever the substance of the particular rule. So in other words, of course, I hugely simplify the distinction between common law and civil law. International law says that rules on liability and responsibility do not travel together with particular substantive obligations. So it is not law of tort. Conversely, what it does say is that whatever the substance of the rule breach, so it may be a rule relating to investment law, on human rights law, like in my examples, rules relating to law of the sea, if they are breached, certain consequences will fall. Part 1 tells us, in more general terms, when international law is breached. It tells us, perhaps somewhat commonsensically, one would think that international responsibility arises if a state breaches its obligation by conduct attributable to it. So we are interested in knowing whether it is the state that has breached international law and whether it is something that is attributable as a matter of conduct to the state. And that is a very important point in investment arbitrations, for example. In investment arbitration, it is common for the first issue to be raised by the respondent state is to say that this is not an issue of breach of international law, at most a contractual dispute, and this is not something that has been done by a state, it is something that has been done by private actors. Now, if we conclude that there is a breach of international law, so the first part has been satisfied, we get to the second part, and that is something that we'll really be spending all our time on today. The second part tells us what the legal consequences for the breach of international law are. And there, International Law Commission said a number of important things. It said that there are certain legal consequences that relate to obligations of the state that is breaching international law, that the state has, again, I think all very commonsensical things that one could sort of imagine them in a classroom with a misbehaving student, that first of all, states have to stop misbehaving. You have to resume compliance. And the fact that you are misbehaving doesn't affect the validity of the rule that is binding you. But also, there is a retrospective point, something that would be reflected in many of domestic legal orders, the idea that the wrongdoing state has to provide full reparation. And that the state has to provide full reparation, if necessary, in multiple forms, which are three. The International Law Commission flags them: restitution, compensation, and satisfaction. Now, in dispute settlement practice, increasingly both states and non-state actors bringing claims are particularly interested in compensation. Satisfaction is also important in its own way. It's often, if an international court recognizes that a breach of international law has taken place, that is viewed as satisfaction. And restitution is also of importance, but it's really compensation, the idea of a monetarily transferable, economically accessible value in monetary form that courts and tribunals are increasingly interested in. Now, why should the International Law Commission consider this topic now? in 2026, and that was a sensible question within the International Law Commission. We have to make an effort to persuade first our colleagues within the Commission and then states in the General Assembly that one should start on a new topic. International Law Commission works quite slowly, so it's quite likely that a topic might take 5 to 10 years. There are only so many topics that International Law Commission can look at, so it's important to explain why it is something for which there is a need by states and the broader international community, and that International Law Commission is capable of providing an answer to that. My argument is essentially threefold, the three reasons why it was important to look at the matter and to go beyond the 2001 articles, which address compensation only in very general terms. Indeed, the title of my topic, Compensation for the Damage Caused by Internationally Wrongful Acts, is almost literally everything that the International Law Commission said on the issue in 2001. The essential argument was that in the last 25 years, international dispute settlement has identified many important issues for dispute settlement participants that have very high legal and policy stakes, and also provided a great deal in terms of useful practice, both in terms of dispute settlement and state practice more generally. So the contribution that I suggested one could have was threefold. First, the focus and depth of analysis would move beyond what was possible in the earlier, more general engagement with the law of international responsibility. And recall, I was telling you about all the many things that International Law Commission in 2001 wanted to deal with. So it was responsibility starting with issues of attribution, breach, considering questions of circumstances performing wrongfulness, and so on. Many issues in part 2, and I didn't even mention part 3 about invocation and countermeasures. So naturally, even though we did an excellent job, and courts and tribunals have greatly relied upon it, it didn't have time to go in great detail in this particular issue. So that would be one advantage. The second advantage would be to build on the increase and diversification of decisions of international courts and tribunals concerning compensation since 2001. I also promised that the topic would move beyond the interstate limitation of responsibility set out in Article 33 of the 2001 articles. If I can pause here and just to say that was another reflection of the International Law Commission's thinking in 2001. It was focusing on the responsibility that one state incurs regarding another state. So matters of great importance. So, again, the cases that I mentioned between Marshall Islands and Equatorial Guinea and the Russian Federation of Ukraine are important interstate disputes that raise questions of reparation and compensation. But really, the most striking development in the field of international courts and tribunals in the last 25 years is emergence of non-state actor-driven dispute settlement bodies in really two respects. One, and I simply note and will not go in greater detail about it, is development of regional human rights courts. European Court of Human Rights, Inter-American Court of Human Rights, as well as the African Court of Human and People's Rights, but also, and of particular importance, investor-state arbitration. So a great deal of decisions by investor-state arbitration tribunals have engaged with issues of compensation. Indeed, one need not be excessively cynical to assume that it is precisely sort of the tail wagging the dog sort of way, that is a reason why investment arbitration is viewed as an intellectually exciting topic. It is on its own merits, but the fact that it may come attached with all the billion of words certainly does not hurt in that endeavor. And when engaging with questions of compensation, investment arbitration tribunals have tended to very extensively rely on the ILC work. So there is a body of practice and arbitral and judicial decisions that, formally speaking, falls outside the 2001 articles. So my promise was to also address, as part of the topic, the obligations, the right to compensation arising from the international responsibility of a state or an international organization, which may accrue directly to any person or entity other than a state or international organization, particularly in human rights and investment law, and also an obligation of international organizations to provide compensation. So simply noting something that is interesting, and also it is very interesting regarding international arbitration, arbitrations between non-state actors and international organizations, an important field of practice, something that has also very much arisen in the last 20-ish years, but I simply flag it without going into greater detail in it. And the third reason for going the topic is that the body of relevant state practice and decisions of international courts and tribunals since 2001 would enable identification of the best examples of application of the rule on compensation, taking into account developments in specialist fields, including investment protection law, and including on valuation methods. So in short, there are important developments. There are important developments in fields formally falling outside ILC's area of work. Therefore, it is important to consider. Well, my colleagues were persuaded. States had an overall positive reaction, although there were things that they thought should have been done a bit differently. But overall, there was considerable sympathy for the idea that these are important matters that have high stakes, and therefore they are worthy of being dealt with, of course, with great care, appreciating the sensitivity of policy issues. And I think here perhaps it is worth noting one interesting shift in international dispute settlement regarding compensation compared with the last century, where in most disputes, the question would be immediately perceived through the lenses of investment protection and particularly nationalization of natural resources, where many states and investors would immediately put themselves on either one side or the other. So they may be independent or newly decolonized states that want to exercise the permanent sovereignty over natural resources, perceiving the long-standing concession contracts over natural resources as being quite unfavorable to their economic developments, or conversely investors or their states of nationality who perceive these issues as affecting the acquired rights in the context of property. So if two groups of states are only capable of seeing the situation via the lenses of a particular dispute, it is less likely that a balanced rule could be created. And that, I think, is one shift, because in investment arbitration, as you would have learned or will learn in the following lectures, now claims can go in all directions. So Western European states and United States and of America and Canada, traditionally states from which claimants would sue other states, are themselves respondents in many cases, so are capable of perceiving arbitration and dispute settlement rules both as potential respondents and as potential claimants, or states that have nationals that are potential claimants. And there are other broader issues where, again, states may see themselves on one side or the other of the situation. So climate change, for example, claims regarding historical injustices, claims regarding war claims or other matters, human rights claims. So if you think through countries that you're familiar with, your particular countries or neighboring countries, it may well be that you will appreciate that on many of these topics, they will fall on multiple sides. So it could be that some states are maybe concerned about rules being excessively far-reaching when they are likely respondents in claims regarding climate change or historical injustices, or insufficiently far-reaching when their investors are bringing claims against foreign countries. So this complexity, the ability, or perhaps rather inability, to identify with one sort of procedural actor is something that is more likely to provide for an environment of where sensible rules may be appreciated by consensus. Whether that proves to be the case or not, we will see. We revisit this issue in 5 or 10 years and see whether that has actually been the case. So, how would I intend to address the issue? So really the question of what sort of things would be covered and what sort of things would not be covered. The topic is entitled Compensation for the Damage Caused by Internationally Wrongful Acts, and in some respects, as I said apologetically in the beginning, it's a bit of a mouthful for title, but every word has its reason. There's a reason why these words are there. So let me start from the end. Internationally wrongful acts. Internationally wrongful acts makes the important point that the topic is limited to breaches of international law, because there are also rules of international law that require compensation as a matter of compliance with the obligation itself. As in investment law, the clearest example is given by the rule of expropriation. Expropriation is not a presumptively wrongful act for which the state has to compensate. It is an exercise of the lawful right, accompanied with certain criteria of lawfulness, non-discrimination, public purpose, and payment of compensation. But that is not something that is triggered by wrongfulness and would therefore not fall within the topic. There are also obligations, or perhaps let me just retract a bit, there are rules that emphasize cooperation rather than compensation or liability. That is a language that is used by the climate change treaty regime of the Loss and Liability Fund. Very important institutional framework within which parties to the Paris Agreement are trying to provide the funding for the measures taken particularly by developing countries on mitigation and other matters. But these are matters that are not based on wrongfulness. Indeed, a very important part of the matter is exclusion of that possibility. There were several interesting points raised by states. Let me just say briefly one point where I was persuaded to slightly change my position. It was a point raised by Chile that wanted me to consider whether rules regarding circumstances precluding wrongfulness would also be addressed within the limits of this topic. Now, the more careful listeners among you or international aficionados may recall that I mentioned circumstance precluding wrongfulness as something within part 1. So those are the sort of things that if a state successfully demonstrates that it has committed a breach of international law, but it was justified or excused by necessity or force majeure or distress or countermeasures, the question arises whether or not it has to pay compensation. And the International Law Commission in 2001 said, in a slightly, unhelpful would be an unkind way of putting it, but in a way that is perhaps not the most informative, that 2001 articles are without prejudice to the question of material loss for material loss in relation to circumstance precluding wrongfulness. And that is something of great practical importance in arbitrations, particularly investment arbitration. There were many cases in sort of mid-late noughties by particularly American investors against Argentina, arising out of the Argentinian economic and financial crisis, where Argentina argued that it may well have acted unlawfully, as a fallback argument, acted lawfully, if not, then at least it was excused by necessity. And the question of whether that is something that affected its obligation to pay compensation was of great practical importance, because if it did not affect the matter, then within investment arbitration setting, the whole debate might be superfluous. So Chile thinks that these are matters that may well be worthy of addressing, even though formally speaking, they do not arise out of a wrongful act. So it's an act that may seem to be wrongful, but its wrongfulness is precluded. And I indicated in my first report that I would be open to considering the matter. As I noted, this is an issue that would only apply to compensation for the damage caused, not apply to other forms of reparation, so it would not apply to restitution or satisfaction, but it would apply to other rules of international law that are necessarily implicated by ruling on compensation. So I would intend to consider causality, types of injury, mitigation, contribution, and interest. I would not consider, and perhaps that might be a bit of a disappointment for students taking an international arbitration course, dispute settlement institutions. Because the position that international law takes on these matters is that responsibility arises and is implemented whether or not particular institutions exist. So essentially, it is up to particular treaty parties to set up institutions, but when they discuss the substance of the issue, they would look back at what the courts and tribunals have been guided to do in the articles on state responsibility. Another important question that I already alluded to is the question of the personal scope. You may remember that I said that the International Law Commission in 2001 wanted to look only at the interstate matters. And the argument that I presented and that states were overall receptive to in the General Assembly was that because of the importance of the investment claims, states particularly sensitive to it as respondents, Argentina was the state that called my attention for the need for great care in approaching the issue of compound interest. These are matters that should be addressed because ILC should be trying to tackle things that are of practical importance. It would not, however, consider issues of responsibility or regarding responsibility of individuals in the criminal setting. So just state responsibility extended to organizations and the responsible end, and extended to individuals at the other end. So that is as far as scope goes. In relation to substance, I propose to address 9 questions. So these are probably only setting in a programmatic manner things that could be tackled in the reports over the next 4 or 5 years. It's perhaps sometimes a bit easier to be an academic if you don't have to write your essay by next Monday. Deadlines have their merits. The first question relates to the framing of compensation. One element is the question about the interaction between the general and particular. Recall that ILC took what I described as a more of a civil law framing, that responsibility rules apply in relation to, in principle, all substantive rules, and all institutions. There may be lex specialis, there may be institutions that have a more limited mandate. Sometimes they do not look at the full panoply of the responsibility issues, perhaps just at the facts. But generally, the starting point would be that these are the rules that are applicable everywhere. At the same time, they have to be sensitive to particular dynamics in particular institutional settings. So that is one tension of drafting rules that are equally applicable and equally helpful, whether the case is considered before an ICSID tribunal, a PCA tribunal, a PCA tribunal dealing with interstate cases, International Court of Justice, interstate arbitration, Regional Court of Human Rights, and so on. Another question is whether there is something particular raised by the intellectual leap from the 2001 articles limited to interstate responsibility to inclusion of non-state actors. And so the question of whether the type of procedural actor who is bringing the claim is something that would have an influence on the substance of the obligation that the responsible actor would have in their regard. That sounds a bit abstract, but to think about it in actual practical dispute settlement terms in arbitral tribunal, the question could be whether in an investor-state arbitration, an investor could ask for restitution, whether an investor could ask, for example, for the law, the piece of domestic legislation that is unlawfully expropriating property to be set aside. In traditional interstate law, restitution, and that would be juridical restitution, is one of the available forms of a reparation. Should the same principle apply also if the claimant is not a sovereign state but an investor? Now, some people might say that the whole logic of international responsibility is that we are trying to repair a wrong. And a wrong does not change depending on who the beneficiary of the underlying rule is. Another point could be to say that this is a relevant consideration, that in other settings we are trying to come up with a trade-off between two sovereign actors. Here we have an important beneficiary, a non-state actor, but one that is not really performing these public functions. I do not currently take a point on which is the better view, but that is an important consideration. Let me just perhaps skip over the second point regarding the interaction between compensation and other forms of reparation and say something about the issues to be addressed in going in greater detail. As I noted before, some of the things to be considered are causality, both factual and legal damage, considering the role of material and moral damage in international law, and also something that investment arbitration tribunals have dealt with, and confirmation of the impermissibility of punitive damages. So that is something that international law has been poo-pooing somewhat. Also addressing some issues that are not entirely clear at international law, in particular the question of whether macroeconomic damage is compensable under international law, as well as the question of concurrency and the role of concurrency in determining causality and damage. So what happens if multiple factors or actors have contributed to a wrongful act? That is something that both domestically and internationally courts dealing with climate change claims are struggling with. So does the fact that many state and non-state actors have contributed to climate change make it possible to advance a claim regarding a singular corporate or a sovereign actor? Yet different tribunals have slightly different approaches to that. The next question could be the question of, I spoke about the complex abbreviations, discounted cash flow, other approaches to the determination of value, intersection between law and economic sciences, and the question of how does this interaction operate best. Is law displaced? Is law primordial? Is law framing the economic inquiry? Is economic inquiry fleshing out legal questions? And this may sound like rather abstract points, but they may have very significant implications of multi-hundred million character. Final points relate to lost profit, interest, and finally, the question that I simply flag as something that was left open by the International Court of Justice itself, whether in determining the amount of compensation, account should be taken of the financial burden imposed on the responsible state given its economic condition. And this is an important question and something that investment arbitration tribunals dealing with sort of cases of the sort I described, $5 billion plus awards against Pakistan and Venezuela, probably not an easy amount of money to find for any state, but maybe of particular challenge for some states in some circumstances, whether that is a relevant legal situation. So that takes me to the end of what I wanted to discuss today. And let me just conclude with reflection on several tensions that, in my view, will inform the elaboration and discussion about the international law of compensation and application dispute settlement for the next years. One is a tension between the general and particular, and the idea of having a rule that is applicable across the board to breaches that relate to obligations of very different substantive character, but at the same time taking into account the particularities, both of the substance and institutional setting in which they are implemented. And for arbitration in particular, it would mean that these are rules that are sufficiently clear and the clarity about their content is sufficiently widely shared to be capable of implementing these very peculiar bodies. I mean, their commonplace might really, we may understating the peculiarity that are really just being born and die off after the particular dispute. There is also the tension between the rules on wrongfulness and rules relating to substance. So the extent to which the legal principle that the same rule applies to breaches of environmental, climate change, space, humanitarian law apply. Are there ways of incorporating some elements of that consideration? And finally, tension between secondary rules of responsibility and what some have called tertiary rules of disputes, that the extent to which mandate and self-conception of judicial function influence development of compensation rules in these settings. So lots of very macro questions of the matter, but also with very immediate, and I think really coming back to my opening thoughts, very immediate practical implications for those preparing claims and arguing them before arbitral bodies as well as before permanent international courts, as well as for the courts themselves, who assist adjudicators in the matter of crafting decisions that could be accepted by the broader community. It hopes, of course, that the International Law Commission will provide a small nudge for development of international law in a desirable direction. That might be appropriate for you to